Yeah, so those who've just joined us, we had a bit of internet disruption from an end. So what we started doing was that we actually going through possible, if you like, areas which we could, for example, try a question or two there. So we said that we're going to be structured. So we started from Ghana legal system before the interruption came. And Ghana legal system, I put it down that I remember that the area which I've been examining before, looking at the past questions, of course, I may be mistaken and you can gradually correct me. The area that I remember as having been examined is the sources of law. And I asked the audience or participant if from their own research in terms of past questions and all that, whether apart from sources of law, there is any other area in Ghana legal system and legal method which has been tested in the law school entrance examination before. But those who were here, as at the time I asked the question, I did not get any addition. So those who have joined us, if you are aware of any topic in legal system which have been tested in the Ghana School of Law examination before, quite apart from sources of law, share with us so that we know that these are the areas which have come before. And any other apart from sources of law? Okay, and then it appears we don't have any addition. Good. Then I made the point that with respect to sources of law, despite the fact that it has been examined before, we cannot dismiss it completely because there are various aspects of the sources of law. There can be like a general question, as I think the one which came, it was a bit more general. And then we can also have like an aspect, a specific aspect being examined, especially if you take this issue of the constitutional instrument, or if you take like the broader subject like subsidiary legislation. Subsidiary legislation, for example, an aspect like that can just be the full subject matter of a question. So in our preparation, let us, much as it's been examined before, doesn't mean that we should just ignore it completely. And if you look at the question which came previous, as I said, it was more like a general stuff around source of law in general, but you can also get a bit more specific about sources of law. Either they can even ask you to discuss the common law, of Ghana, the common law of Ghana, and probably demonstrate how different is it from the received common law, as it were. And I tell you what, as far as this examination is concerned, much as we actually raise our expectations in terms of where the questions should come, it will surprise you if you look at it. Some the questions are very simple. Your examiners, sometimes they are not too, they don't bring, advanced things. So much as we need to be well prepared, don't let us also ignore simple things, okay? Don't let us ignore simple things. And so what will be painful is that you've learned most of the big stuff, most of the a bit complicated topics, and then simple questions are asked, and you are not able to, for example, do justice to them. And I give you an example before I leave sources of law, which I'll flag up. For example, say you are very ready for the exams, and then you are asked to discuss the rule in Angu versus Atta, and how the 1992 Constitution has modified it. The rule in Angu versus Atta, and how the 1992 Constitution has modified it. It's very simple, but if you don't know, you don't know, isn't it? If you remember, Angu and Atta is where, during the colonial era, the attitude of the courts was that customary law was a question of facts, not a question of law, unless it has been proven over and over again, for it becomes so notorious that the court is sufficiently familiar with it, in which case a proponent of a rule of customary law could be excused from having to adduce or marshal evidence to actually establish that. But we have actually changed this, of course, since 1960, when we got our Courts Act after the adopting the First Republic, and it carried through 1969, 1979, 1992. If you look at the Article 11, read together with the Courts Act at 459 as amended, and together with the Evidence Act of 1975, where we are told that the customary law is not a question of fact, it is a question of law. And since in our legal system, questions of law are answered by the judge doing his own independent research, as it were, customary law is also a question of law now, and not a question of facts. But then, assuming you have this as a question, that notwithstanding, because customary law, if you look at Article 11, refer to the rules which by custom applicable to particular community in Ghana, it may well happen that you are a judge. Let's say you're a judge from Ho, right? So you speak Ewe, you don't speak, let's say, Asante, and you are brought to Kumasi. And then somebody has, for example, there's a case, and then the parties are asserting rival versions of a rule of Asante customary law, for example. Yes, you will still need to be assisted to actually know the content. And that is why, if you look at the Courts Act, in sections 55, section 55, 56, and 54, thereabout, the rules on judicial ascertainment of customary law, you notice that the procedure is there. So in preparing for a source of law, despite the fact that is tested before, it will not be out of place for you to acquaint yourself with the steps which the court or the judge must go through before an alleged rule of customary law can properly be established. And of course, in all this too, you also have to remember the rule of the National House of Chiefs and also the Regional House of Chiefs. The Constitution imposes a burden or duty on them to systematically compile the rules of the customary law, so that over time it can also assist in trying to establish whether a particular alleged rule of customary law is actually customary law or not. So please, let's keep that in mind. And the last bit I will also flag as we prepare with respect to sources of law, we'll have to be, as I said, the subsidiary legislation or delegated legislation, right? Especially constitutional instrument, and because of the electoral commission is also giving the power to instrument and all that. And you notice how in the past there has been some dispute as to whether the constitutional instrument, for example, was laid before Parliament for 21 days. To be gazetted and all that, 21 sitting days. So let us keep all those things in mind. And then, of course, finally, the Supreme Court has also come out as to whether directives issued by the Bank of Ghana, for example, is it a delegated legislation, for which reason it must also go through the process of being laid before Parliament for 21 working days, sitting days, and not being gazetted and all that. So let us keep that in mind. And finally, on sources of law, don't forget maxims of equity and also equitable remedies. Okay, I've said it here not long ago that much as we like you to revise everything in all the subjects, don't let us despise simple and smaller topics, thinking that, oh, as for this one is so simple to know come. No. If you look at the trend of some of the questions, you notice that for a long, for a substantial period of time, most of the questions they bring, I would say that the simple ones are more than ones which appears complicated. And for that matter, don't ignore simple things, okay? Don't ignore simple things in your revision. You may expect something high, something advanced, and then you go and you have something simple. Look at last year, for example, law of tort. I think the question they brought something on the forced imprisonment, unlawful arrest, and things like that. Very, very, very simple thing, isn't it? And probably, I don't know, that was malicious prosecution. Very simple thing. So don't let us ignore the simple things as we prepare. Good. I think that will suffice for sources of law. So another topic which somebody has put in the chat as an area in Ghana legal system, legal method, which he or she think has not been tested, and assuming the examiner is interested in looking for an area in the Ghana legal system to test. The person who put it in the chat, in the chat stated 2018. Oh, no. So if I understand you well, you are telling me that in 2018, there was a question under Ghana legal system and legal method, and that question was on jury system. Is that the correct position? So meaning that in 2018, there was a question that the jury system is anachronistic and should be abolished. Has there been a question like that before?
Yes, sir.
All right, okay, all right, thank you. Good, so so that one, it means that this, what we call the criminal procedure. Criminal procedure, because that's where the jury system would fall under. So these two areas in Ghana legal system have been tested before the entrance examination, okay? But again, as I said, despite the fact that has been tested again, we still don't have to ignore it completely. You don't lose anything if you use 5 to 10 minutes of your time to quickly revise that, which has been tested again. Who knows? Good. So what it means is that judicial precedent as a topic has not been tested. So let's keep that in mind. And especially, there's a provision in the Constitution that the Supreme Court, is not bound to follow any other court's decision. It may follow its own decision and then depart from it where it appears right for it to do so, for example. So judicial precedent is not being tested again. So let us first understand it, and then let us also understand the constitutional provision that Supreme Court is bound by its previous decision, except where it wants to depart from it. And then let us also know the mechanisms which are available for circumventing, if you like, binding precedent, for example, distinguishing, or where you can demonstrate that a particular precedent, for example, was per incuriam, that is to say that the decision was given by a court whose decision is ordinarily binding, but the decision maybe did not make reference to a very important statutory provision bearing on the matter, or as it were. So therefore, you're going to demonstrate that that decision, for example, is wrong in law, is per inquilium, and for that matter should not be followed, and so on. So please let us look at that. I think that should suffice for judicial precedent. So for legal system, again, we should also appreciate the relationship between alternative dispute resolution and then the and civil litigation. Okay, so that is another area. So maybe, if you like, the civil procedure or civil litigation system and its relationship with the versus ADR, alternative dispute resolution mechanism. So maybe that is another area that you may want to look at if you haven't already revised that. So the civil litigation, not much is expected of us. All that is expected of us is to just have a bird's eye view, right, of the various steps involved, the various ways of commencing an action and all that. And as you do that, you are supposed to pay attention to, if you like, the challenges, the problems, inherent or associated with the civil litigation system, so that when you are invited to make a case, whether you think that alternative dispute resolution mechanisms should be fully integrated into resolution of dispute in Ghana. Maybe if you are asked to, for example, make a case, you should be able to know the obvious weaknesses, the deficiencies or demerits of the civil litigation system, and that should enable you to also explore the benefits or the strengths of the what do you call the strengths of the ADL, alternative dispute resolution mechanism. So let us pay attention to that. So once I think we look at that, we are very good as far as that topic is concerned. I think the other thing which I will probably, it's not big, it's one of those small things, but it's not out of place. If you know the distinction between res judicata, okay? Res judicata, yeah. I mean, estoppel per rem judicata, or just simple res judicata, and then the difference between the binding, judicial precedent. Yeah, so that is another thing in the legal system and legal method that you may want to pay attention to. Yeah, and then finally, the difference between consolidating legislation, okay? Consolidating legislation and then codifying legislation. And codifying legislation. Yeah, so I know res judicata, in case you've forgotten. Yes, can anybody tell us what it is? Res judicata, what is it?
Doc,
Yes, Kojo, go ahead.
straight away, just simply by saying that litigation must end at a certain point.
Okay, good.
That's the simplest definition.
Okay. And then how does it actually play out? Like how yeah, that is true. So how the mechanics, how does it work out? How does it apply?
Having gone through, let's say, litigation from the lower court up to the highest court or the apex court, that is where it ends. Maybe after a review, it ends there. You cannot go back on the same issue or similar facts and then restart a case on it. That's how I understand res judicata.
Okay, all right. So
Okay, so Doc,
yes.
In addition to what my brother said, in the case of Re Sechodumase 2,
Yes.
it was maintained that once a case is settled, there is no need for the court to go back to revisit it. So I think once the judicial mechanisms have been exhausted fully to its potential, the court will not be interested in going back on matters that have been duly settled.
All right. Okay. All
Thank
right.
you.
Thank you. Thank you. Yeah. So Joshua, that is it. So once the interests or the rights of the two parties making conflicting claims against each other, once the interest or the right has been established, the court having considered the relevant facts in the law and all that, as he rightly said, litigation must come to what? An end. And the public policy justification is that over time, human memory is quite limited. The longer things take, we begin to forget about it. And for that matter, if the matter came up, evidence was fresh and all that, you've gone through the mechanisms, that should be it. But res judicata, as you know, is applicable to the two parties, right? So whereas precedent is not just the parties. Precedent is for the entire legal system, depending upon the appropriate level of the court, which laid that down. So let's keep that in mind. Okay, what is the difference between consolidating legislation and codifying legislation? Yes, anybody? This one, just take advantage to be testing what you'll be learning. We have less than 1 week. Yes, what is it? I think that will not come, so we should ignore it. Okay, let's ignore it.
No, sir, that's not it. It means that we don't know. Kindly guide us.
Consolidating legislation and codifying legislation. Okay, so consolidating legislation is where you have the law relating to particular subject matter or thematic area in various pieces of legislation. But at some point, or where you've had various amendments, so that the law is just scattered all over. So at some point, you want to bring everything together. You want to synthesize the disparate or the separate pieces of legislation on that thematic or that particular subject matter into one. So that one, it is consolidating legislation. And it is more of synthesis rather than trying to make any reform of the law. So it's just like a neat arrangement and piecing everything together and show there's a bit of like coherence. Yeah, but the codifying legislation on the other hand, yeah, George, I'll yield in a second to you. Codifying legislation on the other hand is not just synthesizing scattered pieces of legislation, but actually trying to systematically bring the whole law relating to particular subject matter or thematic area into one piece, and while ensuring that there's a coherence, ensuring that there's a unifying objective or philosophy or value for that particular subject area that you are trying to systematically bring all the law together. So codifying legislation will also sometimes involve reforming the law. It also involve looking at the relevant legislation, like decided cases. So it's not only legislation which you are dealing with, you also be dealing with the decided cases. You may also be dealing with the new legislative like policy guide. So long as they all relate to the particular thematic or subject area, then you bring them together, and then so they have like a fuller statement of the law in a very systematic fashion. So you notice that the codifying legislation is more pronounced, more profound or deeper than just a consolidating legislation. Yes, George, you wanted to say something, please.
Yes, Doc. I wanted to know where Act 1036 will fall under. Whether
Is it the land?
The new Land Act, yes.
Yeah.
Is it will it fall under consolidating or codifying?
Okay, all right.
Since we know, okay.
All right, yeah. So the Land Act at 1036 can conveniently be treated as a codifying legislation, except that let us quickly add that unlike the civil law tradition, where they have like the proper understanding and proper use of the concept of code, when you come to the common law tradition, when we use code or codifying legislation, we are a little bit more flexible than them. Because in the civil law tradition, if you say that you have a code on this, everything related to that particular subject material is found in the code. But here, it's not like that. We take the Companies Act, Act 992, is an example of a codifying legislation. And yet, if you go to some of the provision, either as in section 216 and so on, reference is still made back to the common law, to doctrines of equity, meaning that what you have is not complicit in of the law. Other part of the law is located in the decided cases. So the Land Act, yes, we can say that's an example of a codifying legislation because a synthesis of not just legislation, some of the core decisions have also been incorporated into it and all that. Okay, so that is fine. So I think Ghana legal system and legal method, probably the other thing we haven't addressed our mind to probably be legal aid, right? Legal aid. So legal aid will not waste time, but because it was recently in the news, if you remember, not long ago, the president and the attorney general, they launched what we call like the legal aid commission fund, and then the law reform commission fund or something like that. So therefore, legal aid, it will not be out of place if you just spend some 10 minutes of your revision time to find out legal aid, what is it? Look at the Legal Aid Commission or the Legal Aid Act. Not a lengthy act, there's a few pages. Just run your eyes through and then know the arguments which supports provision of like legal aid, by the state and things like that. So let's pay attention to that. Okay, I think somebody has also brought the fact that in talking about Ghana legal and legal method, we should not also forget the statutory interpretation. He said that aids to statutory interpretation. Statutory interpretation. Okay. Yeah, I think Ghana legal and we have some basic introduction to interpretation. So it will not be out of place if you just have a quick, just refreshing of your mind. When you say like the mischief rule, what is it? The golden rule, what is it? And then the purposive approach to interpretation, what is it? Then you look at the various, like the aids to interpretation, also like the linguistic aids as well. For example, use them generis. Maybe you're asked to explain how the following concepts or the following devices aids or assist interpretation of statute. If you have like a use them generis, you have a nocita associates or expressio unis and things like that. You should be able to explain yourself briefly and then get illustration as well. And you know how purposive interpretation approach has become very popular in our country. And if you also even look at the Interpretation Act of 2009, you notice that it gives some blessing or endorsement that in interpreting any legislation and so on, the person doing the interpreting should seek to effectuate, so seek to advance the purpose of that legislation. So is that you're trying to advance, trying to get interpretation which actually advances or reinforces the purpose or the objective for which the particular legislation, for example, was made, as it were. Then we also have like the presumption, but I would say that at this stage, nobody will really worry you because you have like a interpretation as a whole course in the professional and in part 1 or part 2. So once you have like the basics, concepts, I think that should be enough at this stage. Okay, so let's leave in the Ghana legal system, and then let's come to contract. So as for contract, all of you are supposed to be masters because it's an area which is, examined often. If you look at the history of the Ghana School of Law entrance examination, ever since it started, one will argue that almost every year there is a question on contract. And those who are the chief examiners of the entrance examination, if you look at their background are mainly constitutional law and contract and probably taught. So not until maybe probably they change, but we don't know. These are all not public information. But if you look at the questions which come, that is what enables me to make such a claim. If you examine like the question which come, you notice that whoever is responsible for putting them together, the person must have some particular interest in constitutional law, and the person also has some particular interest in the law of obligation, be it a contract or be it a tort, if we look at the question which comes so far. And that is why, so long as we have no basis to think that no, they've probably changed them, we still have to take these subject areas serious without completely ignoring the other subject areas. So having said that, contracts from the law school entrance examination history, what I remember, and again, I stand to be corrected if I make a mistake. What I remember as having been tested, I remember capacity. I think so. I think capacity has been, capacity to contract has been tested before, if I'm not mistaken. Correct? Has it been tested before?
Yes, sir.
Yes, please.
Okay. And then let me say again, apart from capacity contract, which have they done? I think offer invitation to treat or something. I don't know. I think, or even I think intention to create legal relation has it been tested before? Intention. Or not yet? You don't remember? Okay. So contract, apart from capacity, no. I think let me see. Okay, I'm told that in 2018 damages. Okay, the damages came. Damages. Okay, so we have damages for breach of contract. Okay, so 2 areas. Maybe as one area, if they wanted to give you a bonus, as I gave you 2 questions, maybe consideration, especially the modifications which have been made by the Contract Act 1960 Act 25 to it. And then I also mentioned the discharge by frustration. So assuming those who have the interest in contract are still the same people examine you and they wanted to do something in contract, maybe things like this, you may want to probably look at them. Of course, consideration must also always be looked at in relation to privity of contract as well. So, but again, let me say that the fact that capacity has been examined before does not mean that you should just ignore it completely. If I were you, I would just use some 10 minutes to quickly remind myself of what the rules are, capacity of minors or infants. I remember some examiners having a debate regarding students, some students writing 18 years as the age of a minor and others writing 21. And I think the consensus among examiners probably mean, contract teachers will be that. If you say 18, you are not wrong. If you say 21, you are not wrong. And 18, a lot of legislation coming up, which seems to reinforce the idea that the capacity for transactional purposes is 18 now, except that we don't have any. Okay, somebody has told me that the privity of contract has come before. Okay, so privity of contract has come before. Okay, privity has come before. So these are the ones that have come before. Yeah. So capacity damages, privity have come before. So consideration has not come before, for that matter. But of course, as I indicated, there's no hard and fast rule that the fact that a topic has been examined before, it will not be examined again. No. As for that one, nobody can guarantee that. So the best strategy is to look at everything. All these things we are doing, we are only just doing an exercise in speculation, right? Or what they call intelligent guessing. That is what we are doing, not really anything really serious. But last night, those on some of the platforms, I put in a question there, or in respect of a contract that let me look at how the question, I don't know if I have it. Let me look at how the question was framed. Yeah, I think the question was that discuss changes made to common law doctrine of consideration under Ghanaian law. Some of you have tried hands and some of you have sent it to me, and I've not been able to open all, but some of you, yeah. So basically, it's a very straightforward question. A typical essay question. So you will explain to us what is meant by consideration, and in doing that too, or quickly, you have to tell us that consideration is a requirement for enforcement of a simple contract. A simple contract, also known as the what they call the parole contracts. So at common law, you couldn't enforce a simple contract unless it was supported with consideration. And then you talk about the contract under seal or specialty contract does not require consideration for its enforcement. So having made that point, you go on to say that the common law was so strict in terms of what will be considered as consideration and what will not be considered as what? As consideration. And for that matter, this gave rise to the principle of sufficiency and adequacy of what? Consideration. And by sufficiency of consideration, that is to say that it's not anything which will be accepted as consideration. It might be something of value in the eyes of the law and all that. And then by adequacy, that is not the business of the court to try and inquire into whether what someone is putting forward is a good consideration or is not a good consideration, having regard to what he is receiving and all that. And then you go on and make the point that the rules which evolve at common law have been modified significantly by our Contract Act. So what we are going to do is that you can do this two ways. You can just say that what you're going to do, you state the common law position, you explain it, illustrate it, and quickly demonstrate how our own Contract Act 1960 Act 25 has modified that particular rule, okay? And then you move on to another common law rule, you explain it, and then you demonstrate how a specific provision of Act 25, for example, modified it, and so on. So when you are done, you do your conclusion, because the question said that discuss changes made to common law doctrine of consideration and the Ghanaian law. So your conclusion, you just pull everything together, just summarize your key arguments, and then you make the point that although consideration has not completely been abolished, by and large, it has been rendered redundant in a number of ways based upon the discussion that you have made. You finish your answer. You finish your answer. Is there anything somebody would have loved to add to this particular question, which I haven't touched on? Is there anything that you think we omitted or could have been added to enhance the response? Yes, Azun Taba, please.
Please, do good evening.
Good evening.
Yeah. Please, I want to find out in one's quest to answer that question, whether it is possible to also add something on the types and then explain them under consideration, types of considerations.
Yeah, it's not bad, but it's not really essential, because if you look at the it said that discussion made to the common law doctrine of what consideration and the Ghanaian law. So if, for example, if the particular type, maybe like what we call past consideration, okay? So past consideration, if you remember the provision in the Bail of Exchange Act, 1961 at 55, if you remember the provision which says that an antecedent liability shall not be or shall be a valuable consideration, right? An antecedent liability is a valuable consideration for a bill of exchange, be the check or promissory note or whatever. Antecedent liability simply means that, for example, maybe I did some work for you or gave you some goods and you're owing me. So you write a check for me. The check that you have written is a promise that should I present that check to the particular bank against whom you drew the check will be honored and it will be in cash for me. So that is a promise. Therefore, if I present it and it is dishonored, it's like you've breached a promise. And question which will arise is this: what consideration have I provided to justify the enforcement of that promise as represented by the check? So the Bill of Exchange Act will say that if I can show antecedent liability, if I can show a past debt, right? So here I supply goods to you, which you haven't paid. So that is a past debt. That is the antecedent liability. And the law says that that is a good consideration. Ordinarily, common law have said that that's a past consideration. You know, past consideration, let's remember common law, that is not a good word, consideration. But here, our lawmaker is saying that this is a good consideration. So if you wanted to, for example, include that, then it will be acceptable for you to talk briefly about the type. But if you are not going to, because the question said that in what ways, like discuss the changes made to the common law doctrine of consideration. So at common law, we know the rules on consideration. How have these been modified? How have these been changed under our law? So that is the focus of the question. Okay. Okay, somebody has brought. Okay, now just before we look at that person's question on contract, I think there's another question I also added yesterday. those of you who are on the platform, you have seen that to what extent has Ghanaian law improved recovery of money under illegal contracts and frustrated contract? So that is a double-barreled question. Again, the approach is similar to how we did the question on consideration, because the question presupposes that we have the common law rules on how to recover money under illegal contracts, and that those rules, for example, are not satisfactory. And for that matter, I show how Ghanaian legislation or Ghanaian lawmaker or Ghanaian courts have actually improved the common law approach. So, like for the illegal contract bit, very straightforward. So a question like that will require that part of your introduction, you explain to us that the contract may be what? Illegal either at the inception or at the performance and all that. And monies might have been transferred under such a contract, or monies may be owing under such a contract. And there's a controversy as whether a contract which has demonstrated to be illegal, whether you can actually recover any money under it and all that. You know the common law, what the position was, very straightforward. If both parties, you are not equally guilty, what they say, you are not impar delicto, if there has been conversion or change of mind before you did it, the locus ponentia, and then the severability doctrine. If you can sever the illegal bit, from the rest of the contract and so on and so forth. So the common law is very straightforward. We've done a discussion on this previously. We can play the lecture on it back. But with respect to Ghanaian law on recovery of money under illegal contract, if for nothing at all, we should remember what the Supreme Court, through Justice Datiba, Professor Datiba, did in the case of the City and Country Waste, right? City and Country Waste Limited against Accra Metropolitan Assembly, where our Supreme Court said that we don't have to just follow the common law approach, line, hook, and sinker, and we must rather have what we call like the structured approach in trying to determine as whether monies can be recovered under illegal contracts. And that approach, the focus should be on how to avoid unjust enrichment. Unjust enrichment simply means that where you have concluded that the contract is illegal, yes, if you are to say that no money should be recovered under it, will you find yourself in a situation in which one of the parties to the contract, for example, has taken advantage of the other party in the sense that he has made money off the other party when in fact he's not really done anything for him? So that is unjust enrichment. So in order to achieve restitutionary justice or restitutionary outcome, the court will look at the circumstances of the case and make a determination as whether monies should be recovered under a contract which have been declared to be illegal. So if you remember the Accra, Metropolitan Assembly and the Country and City Waste, and in the sanitation contract, I think AMA did not really follow strictly the procedures which Assembly should go through to get a contract signed. The Country and City Waste Limited actually did the work. Similar to some of the things I feel like a Zoom Lion do. They did the work and all that, the sanitation services. And then when it was time for them to get payment, there's a default, it goes to court, and then the AMA is trying to say that this contract is even illegal because we didn't follow what the law says we should do. Meanwhile, they have benefited from the services of this sanitation company. So it was within that context that the Supreme Court said that if we are to go strictly by the common law approach, you'll be condoning and then permitting unjust enrichment. AME having benefited from all these services, they haven't paid anything and all that. So that is what we should keep in mind. Then the second part of the question, that is about how to recover money under frustrated contracts. So, of course, in the introduction you have also explained what the frustration means, and remember the good way in which Lord Radcliffe, for example, put it in Davis Contractors against Fareham UDC. And then you don't need to waste a lot of time telling us all about things we know about frustration. To just suffice, just to make the point that what is going to be frustrating event should not be the fault of the parties, and that self-induced frustration, as we know, will not be. And then it may come about as a number of circumstances, changing subject matter, changing government policy, and so on and so forth. Now, you are just going to be very brief on that. Now you come to when it's being concluded that the contract is frustrated, what happens to monies, for example, paid under the frustrated contract, or monies which are meant to be paid before the contract became frustrated, or expenses which have been incurred in an attempt to perform the contract before the frustration occurred. What happens to them? The common law, the common law simply says that the loss lie at where it fell, meaning that once you were supposed to pay money before the frustration occurred, you still have to pay that money, and so on and so forth. And then remember the famous Fibrosa case came to improve it, to say that, well, unless there has been a total failure of consideration, if you paid money under a contract which has become frustrated, you cannot recover that money. Yeah, and you know how practically difficult it will be to work out as whether there has been a total failure of consideration. That is to say that if it can be shown that no benefit whatsoever or no detriment whatsoever has been enjoyed or suffered, in relation to the money which was paid before the frustration occurred, and so on, that is going to be difficult. So the lawmaker, as you remember, in the Contract Act, Act 25, Section 1, Subsection 1, Subsection 2, Subsection 3, and then Section 2, actually provide the rules which should govern how we work out this particular aspect under Ghanaian law. Yeah, so if you're able to discuss all this, I think you should have a good response to that question. Is there anything which has been omitted in trying to do this question, or anything which you think will have been added to enhance the response? Okay, so in the chat, someone has brought a question that let me copy it and put it so that if I will see it. The person asking me, what is the approach to this question? Let me put it here. The question is this from someone, not me. I just copied it from the chat. the chat box, so you could have also seen it. A contract manager or administrator is responsible for negotiating, administering, monitoring, and enforcing the terms and conditions of a contract. Maybe I think last year there was a development. The day before the exams in the afternoon, I got few other people to join me in the panel. And students were asking questions. Some of the questions that we discussed, they actually came. So my advice is that learn all the topics and subjects. But if you come across any question, don't ignore it, just treat it. After all, don't lose anything, isn't it? By looking at the question. And then, so long as it relates to the same subjects, don't ignore any question. It doesn't matter where it's coming from, whether it's coming from a student or it's coming from a particular school or whatever. Just look at it. It doesn't matter. Good. So this is the question the person has brought. A contract manager or administrator is responsible for negotiating, administering, monitoring, and enforcing the terms and conditions of a contract. Discuss. Okay. This is a question for all of us. And the questioner in the chat said that what should be like the approach? Are there any thoughts? Yes. Any ideas? Are we together? Any ideas?
As for me, no idea.
Okay, so yes, we are all just brainstorming. There's nothing like absolutely wrong answer, absolutely correct answer. Yes. So someone brought this question, which I put in the green. A contract manager or administrator is responsible for negotiating, monitoring and enforcing the terms and conditions of a contract. Discuss.
Hello, Prof.
Yes, please go ahead.
I think the outline will want to see the administrator's role from the execution of the contract. That is what are the salient points the contract is supposed to look at, whether for the execution of a particular project. Then you make sure that at least the said project is undertaken. You look at whether the consideration is in good line. You look at whether the terms of the contract have been respected, and true to the execution and the handling over of the project. So, what the question has earmarked the lines of where the respondent should look at. So it is like you looking through or running the contract by what is the terms and all what there is in the contract, and make sure that finally the contract is settled.
Okay.
Thank you.
All right. Okay. All right. Thank you. Yes.
Good evening, sir.
Good evening.
Yeah, to add to what my brother said, I think you even gave us a hint that we should even be looking at let's say formation of contract. So I see this whole question to be, to be anchored or to be grounded on a formation of a valid contract. Because once a contract is made and it's not valid, its enforceability become an issue. So I believe that it will start from the elements that must be formed when an agreement is made for a valid contract. That is consideration, the offer and acceptance, and the Privity of Contracts and what have you, and also the representations that must be made to know that yes, these are the terms that goes into the heart or into the roots of the contract, and that maybe some of the representations are just a pass-by comment that wouldn't go into the heart of the contract, and that upon breach of it, what will be the results, whether a breach of it will entitle only damage or it also entitle the victim the opportunity to repudiate the contract, that is repudiation. So to add to it, what I see the question to be is on formation of contract from beginning to an end, the elements that must go into it and how it will be enforceable should a party or should a party, I mean, obliged not to carry out the terms in it. Thank you.
All right. Okay. Thank you. Fred, hand is up. Let's hear Fred. Then I'll say a few things and move on. Yes. Yes, Fred, you can mute yourself or mute yourself. Click on the mic, that red thing, then it will be unmuted. Let me see if I can do it for you. No, you see, if you look at your distance, you see I think on your left, there's something red. Then there's something across it. That's the mic. If you click on it, it will be unmuted, and then we can hear you. Oh no, we cannot hear you. We can see you talking. We cannot hear you, but just click on the. Look at the. How best can I describe this? You see something like a red thing, right? It's like the mic. So click on it. No, if you click on it, when you talk, we'll hear you talking. Oh, sorry. Then you put it in the chat. You read what you have to say. You're not able to unmute yourself. Yes.
I think it's done, right?
Yeah, it's done now. Yes, it's done. It's done.
Okay. Thank you. I think basically the question talks about the terms and conditions of contract. So probably I would think you start by defining what contract is. Talk about elements of a valid contract. Then you limit yourself in discussing the question to terms and conditions of a valid contract. That's my opinion.
That's your opinion. Okay. Okay, good. All right. I think all of you have valid points that you are conversing. If you have, okay, let somebody else put something there. Okay, somebody, yeah, we get to thoughts. So when we get there, if you have a question like this, as we have like in the green, of course, the question sounds a bit weird, but let's assume, that's the question. So the challenge here is a focus on the duties of a contract manager stroke contract administrator. Certainly no, because we are not doing a specialized field of contract. You have various specialized fields of contract like employment contracts, right? You even come to football, contracts and so on and so forth. So construction contracts and so on. So there you can, for example, say that somebody is like a contract manager or somebody is a contract administrator. And that is just a red herring. You shouldn't waste so much of your time. So as you've rightly know, the focus is on terms of contracts. That's like the main focus of like the question, terms of a contract. So when it comes to negotiation. And some of you made attempt that, well, in negotiating a contract, a lot of things are said. Not all the things will actually end up forming part of the terms of the contract, isn't it? And of course,
Yes.
in the introduction, you have told us that terms of contract refers to the content of what? Of the contract. It embodies the duties and then the rights of the parties. And they come about through the negotiation, or what do you call it, the pre-contractual stage negotiation. And some of the things which are considered important will become part of the terms of the contract. Things which are said closer to the time that the contract is actually concluded may find, or if it's made by someone with a certain expertise, they all form part of the terms of the contract, and so on. So you've disposed of like the negotiation, bit. Then you come to, in terms of the terms of the contract, we have like the relative importance. As someone said, we have terms which are very important, and they are the conditions. A breach of it will entitle the innocent party to actually have the contract discharged or repudiated, and then you maintain action for damages. Then we also have the other category, not really important. A breach of it does not affect continuation of the contract, what we call like a warranty. And of course, the recent Hong Kong Fair case addition of the innominate, certain terms where you cannot pre-classify them until there has been a breach. So use like the wait and see what approach. So that when a breach has occurred, then you determine whether the innocent party should be given the remedy for breach of a condition or a warranty, as the case may be. Then again, the question, what we are trying to do, we are just trying to be creative, using our knowledge of terms of contract to pick on words in the contract to respond. So that's what we are doing. So the other thing we should know is that it's talking about administering, monitoring, and enforcing. So in terms of like enforcement, we have covered an aspect of it based upon the relative importance that we discuss. Then we also have to rope in exclusion or exemption clauses, especially because it's also part of like the terms of what, it's only part of the terms of the contract. You may have like a term in a contract which try to exempt or exclude or limit liability. So that is part of it. And then in terms of monitoring and enforcing that, remember issues of interpretation, that when a breach has occurred, then you need to interpret the wording of it, of the clause, to find out whether it actually covers the breach which has occurred and all that. And where you have interpretation which is more than one, maybe one is less advantageous to the person, at whose instance that exemption clause was included, then you go for the, you remember how to call the contra proferentem rule and so on and so forth. Yeah, so these are some of the ways in which you try to respond to the question. Of course, as I said, the question is a bit odd, but I'm happy the person has brought it, because in the law school entrance examination, some of the questions they ask are odd. They are odd in the sense that if you are going by experience of those of us who teach the subject over the years, in a normal examination setting, sometimes the way that they set some of the questions, we didn't set it that way. Nevertheless, that is what they have given you. So you have to try and work your head around it. And that is why you must have a proper understanding of the topic, so that however the question is presented, you'll be able to utilize the store of knowledge and appreciation to creatively respond to the question. So that is all that I will say on that. Well, maybe finally, the other thing I would say on the contract. I'm not saying you shouldn't revise all that. I'm just trying to use a broad brush approach to rush through a lot of areas. Another thing I'll say about contract is that your examiners may probably also be interested in vitiating factors, especially unilateral mistake as to identity. Okay, unilateral mistake as to identity is a nice examinable area if they wanted to maybe give you a small scenario, and then you'll be asked to advise the parties. If you, in case you've forgotten unilateral mistake as to identity, we're talking about where maybe a rogue, right? Someone, a rogue will try and present himself as somebody important and all that. Will manage to get the contract concluded. You often not fully pay for it or use a that check. Then he'll go and then sell the item to another party. The original owner will find it in the hands of like a person that he has never sold the thing to. And he or she may want to recover. Of course, this type of question is interesting because it brings law of contract and law of tort together. You have an aspect of contract, you also have an aspect of tort of conversion, if you like. So that is an interesting. So assuming you have like the just a scenario, and you are just asked to advise the parties, you may have to, because let's say that if you bring an action for conversion, right? That someone has attempted to convert, to take that which belongs to you without your permission and all that. Before the court can actually decide that matter, the court will need to determine the status of the transaction between the rogue and the original owner of the item. So that if the transaction between the rogue and the original owner of the item was, for example, a valid transaction, in which case, as you know, the rogue will have acquired a good title. And once he has acquired a good title, he or she will be able to pass a good title on to the third party, who is now a defendant to an action in conversion, as it were. On the other hand, if the rogue did not get a good title or the title was rescinded or avoided in good time, then as remember the name that code non-habet rule, you cannot give what you do not have. The rogue will not have acquired a good title. For that matter, he or she cannot pass on a good title to the third party, so that the third party will be liable for conversion. So, as I said, it is, in terms of scenario, for exams of your type, is a good area because you have 2 areas of law actually coming together. Well, even 3, because you could also even be thinking of like the criminal offense of what? Of stealing and so on, as it were, assuming you can get all the elements present. So let us keep that in mind. Yeah, I think that it's 11:18, and tomorrow a good number of you will go to church. Ask for God's blessing so that you'll be successful in the exams that you write. So therefore, what I'll do is that tomorrow you continue along the lines that we are doing. So I think we're almost done with the contract. We continue with land law and then tort, constitutional law, criminal law in the way that we are doing. So go and look at the past questions so that when I ask you a question which have come before, you'll be able to share that with me. So have a very good night, and then we see ourselves.
Yeah, Doug. Doug. Please, last year you invited Chief Justice to come and help you. May I know if this year you will be able to do that? And my plea is that you should be able to bring him over, please.
Yeah, have a very good night.